Fabulous. Well, I should have asked if everybody's okay with it being recorded, but I assume it's just assumed these days. So my name is David Scott from Folgate Advisors, and I am joined this morning by Mike Nichols, who is Senior Legal Counsellor and a university lecturer on many topics, but one of the areas he specialises in is in AI and its use. This is one of the sessions that is obviously a little bit delayed, as Mike was unfortunately ill towards the end of April, so we're not quite in April anymore. But this was one of the sessions that I particularly was excited and looking forward to. Coming from a commercial, legal, financial background, it would have always been one of the areas that I was most interested in making sure that whatever we were doing as a business, we were compliant and effectively doing it in the right way. And everybody has been very excited about the use of AI. We've seen that through all of April. But of course, like most subjects, it comes with certain regulation and risks that we need to be aware of and looking out for. So Mike, I'm just going to hand over to you to introduce yourself in 1 second. Everybody, if you wouldn't mind just leaving mics off, you can leave cameras on if you like. If you have any questions, please pop them in the Q&A and we'll either get to them as we go through Mike's session or at the end. But Mike, over to you.
Okay, thank you. Right, I actually wandered into law and regulatory as an accident. I started as a technologist and I was actually writing back in the late 70s, early 80s, applications in a language called Prolog, which were expert systems then, but we'd call it AI now. Somehow I ended up doing accounting and then law at the European Central Bank in Frankfurt for a number of years. And I also, as David mentioned, I'm a visiting lecturer at the University of Law. This disclaimer is here not because I'm a lawyer, although it is because I'm a lawyer, but because a lot of you come from the PR world, and I was once bitten, twice shy. A long time ago, back in the 90s, I was the IT manager for Bank of Ireland, Great Britain. And there was an incident, a bit like we've seen recently with M&S and with Harrods, a cyber attack on Allied Irish Bank. And the Financial Times came to interview me, the peak of my career, to be in the Financial Times. And we discussed it. And the reason AIB had been hacked was they hadn't changed the default passwords on their routers, on their technology. I was walking the journalist out of the building and he said, "So how did it happen?" And I said something that came back to haunt me. It's like unprotected sex. Sooner or later, the consequences will find you out. Thank you. Good day. Goodbye. Next day, I was so keen to see the FT. But before I managed to see it, I got called in to see the chief exec for Great Britain, who was on the phone to my mother. My mother had rung to apologise because in the FT, it said, Mike Nichols, IT manager, Bank of Ireland, said it's like having unprotected sex. Sooner or later, the consequences will catch you out. So, the world of PR, once bitten, twice shy. I picked a theme of Shakespeare because so much of what he said actually resonates with the regulations. And I'm going to go through it very quickly. Would a rose by any other name smell as sweet? What is AI? What does it mean? Why is it important? Well, it's important because if what you're doing comes within the definition of AI, the regulations apply. And if the regulations apply, you're liable to pay fines if you're not compliant. If what you're doing doesn't come within the scope of the regulations don't apply and you can't be fined. Each man in his life takes many parts. Is about the different roles in the life cycle of AI. Much ado about is about risk. Is this a dagger I see before me? is, of course, about hallucinations. The Shakespearean soliloquy goes on to say, a product of the fevered mind. So an AI hallucination in some cases is a product of a fevered processor somewhere in a data center we call the cloud. And then at the end, I'm just going to wrap up with a few observations, the timeline of the regulations you have to comply with, and a short roadmap, which I hope will help you to be more compliant. Okay, would a rose by any other name smell as sweet? Alan Turing, famously the Turing test. If I'm in a room typing on a keyboard, is the respondent, the other party, a human or a computer? Can I tell the difference? If I can't tell the difference, then that's artificial intelligence. This isn't new. This was a paper he published in 1950. So we think of AI as being new, but it's been around longer than my lifetime. The OECD more recently came up with a definition in 2023. And of course, we have a definition in the EU AI Act that we'll look at in a minute. So it's been evolving and it continues to evolve. But there are lots of legislative hurdles and things happening around the world. We are in a moment of tension. When Trump took up the presidency in America, one of his day one decrees was to repeal Biden's AI decree on AI regulation. He asked his people to go away and come back within 180 days. So they've still got a bit less than 80 days to come back with their proposals. Interestingly, you can see China have been very prescriptive in terms of what they're doing with AI. In the UK, you may remember we very briefly had Liz Truss, but before Liz Truss and the lettuce, we had Rishi Sunak as our Prime Minister. And there was a meeting of EU ministers held at Bletchley Park to talk about AI and what regulation, what controls needed to be put in place. And as governments tend to do, they kicked it down the road by saying, we will not legislate. We will leave it up to individual industry sector regulators to legislate. And a lot of them have been saying, well, we were expecting a lead from the government. Because what you could end up having is for one industry, say financial services, to be very strict on how AI is used, and another industry, say telco, being more relaxed. Come back to that in a minute. So it's continuing to evolve, and we have this tension between those people who want to protect the fundamental rights and freedoms of citizens, and those people who are concerned that regulations will stifle competition and innovation. Even though we don't yet have those regulations in place, there's a lot of litigation going on around the world. A lot of litigation. And that includes in the UK. Now, a lot of this litigation tends to be around copyright or data protection or data privacy. In the UK, there is a case which is going into the Court of Appeal called Getty Images and Stability AI, and we'll have a look at that in just a second. We've also had last year, this is one of my favourite cases. I really wish I'd been in court for this. Felicity Harbour has a dispute with the taxman. The taxman wants money. Quelle surprise. She refuses to pay, and it goes to court, to the Financial Tax Tribunal. She puts forward 9 cases in support of her argument as to why she shouldn't pay. HMRC lawyers can't find these cases anywhere. The judge can't find the cases anywhere. The judge asks her, where did you get these cases? She said, I researched them. I said, did you use AI? And she says no 2 or 3 times. Eventually, she accepts that she used ChatGPT. Why is it important? And the judge says, well, these cases don't exist. The AI made them up. They sound plausible, but they don't exist. To which her response was, and this is the bit I wish I'd been there, well, how do you know HMRC's cases exist? They could have made them up. She lost the case. And then we've got the outputs. So this is something which may be of interest to some of you. If you use AI to generate some output, because it's generated by a machine and not a human, it fails to meet the criteria to obtain intellectual property right protection. So if you use ChatGPT to write a document, to write a press release, whatever it may be, you have no copyright in that output. Right.
Can I just jump in with a quick question there, Mike?
Please.
So in the example you just gave us there, how much would you have to change it by with your human hand for it to be different enough, materially different, to comply with those copyright rules?
So we only have an analogy in the UK. It was a case of Bridges in Cardiff. So Mr. Bridges was an interesting character, local councillor. He's walking along and he sees a police van with one of those camera signs on the side of it. And he goes up and he asks them, what are you doing? And someone explains to him it's for facial recognition. So he basically says, I didn't agree to my face being analysed. So he goes to court on it. And some interesting things come out in the evidence that's put before the court, which is all about the number of false positives. The police were using it to look at people at some large football matches to try and identify potential troublemakers. So a laudable aim, you might argue, but still a potential infringement of civil liberties. It wasn't an infringement of civil liberties, according to the judge, because he said a police officer reviewed the footage and the recommendations. A police officer would make the decision as to whether someone was then interviewed or arrested or prevented from entering the football ground. Another analogy, so doesn't actually take very much to show that there has been some human intervention. Those of you who may have suffered from speed cameras, when speed cameras were first being used, the automatic ones, where it flashes as you go by, letter is automatically produced with a summons or a fine. People said, well, and this is under the GDPR regulation rather than AI, but they're quite similar with respect to this. People said, well, this is my personal data. There's been no human judgment involved. Therefore, it's an infringement of my civil liberties. And the court said, again, the police officer had to sign the bit of paper that went out. So, and we've seen some other developments in the law in that area. But the bottom line is there doesn't actually have to be a lot of intervention. But for something like the Davis case, which actually wasn't a document, it was used to design a product. The product couldn't be patented and get design rights because it was designed by a computer. But that's intellectual property right law rather than AI specific. So Getty Images. This is the original Getty image of a football match. Getty Images said this image here infringed their copyright. It even includes the Getty Image logo. This is currently going through the Court of Appeal, so it's not a decided case. Getty Image argument is, look at the similarity. Clearly, they've infringed our copyright. They have scraped our picture and then reproduced it. Stability AI's defense is Getty Images spent time crafting a prompt and rewriting a prompt until they could get a picture out which looked like the input information. So we have copyright versus it's not stored as an image, we're storing something else. This whole area, as I showed earlier, the copyright issue is ticking away. If the courts find in favour of infringement of copyright, then all of that data that's been used to train an LLM, train the AI, has to be removed unless they pay some sort of license fee. There have been figures suggested that on a global basis, it could be 40 to 60 billion in license fees that AI companies would have to pay. They are arguing that it's for the greater good. We have to wait and see what the courts finally say. Right, back to the EU AI Act. Everyone thinks of the EU as an amorphous blob. It's the EU. We hear this every day on the TV. The EU isn't an amorphous blob. It's actually got 3 large organisations, each of which needed to approve line by line, word by word, what went in to what we now know as the EU AI Act. And the other reason it took a while was that in the EU, in the European Commission, in the European Parliament, there were 2 protagonists, one on either side. Margrethe Vestager, a Danish politician, she was very much for protecting the rights of the individual. On the right-hand side, Thierry Breton, formerly the CEO and chief and chairman of Groupe Bull, the French IT company. His concern was about the danger of innovation and stifling competition. There's also an anecdotal thing. I haven't seen any evidence to support it, but it's an interesting story that one of the reasons that the EU AI Act was delayed was objection from France because they wanted to use it to analyse, like in the Bridges case, CCTV at the Olympics. If the regulations had come in before the Olympics, they would have had certain obligations to comply with. So it was delayed until after the Olympics. Anecdotally, I don't know if it's true, but it's a very good story. We've got this emerging framework. It's not just the AI Act. It's also GDPR, it's cloud, it's data. There was, in parallel, a draft AI liability directive. Vendors, AI vendors, did not like this for 2 reasons. One, it shifted the burden of proof if something went wrong onto the AI vendor. Normally, in a tortious loss, the person who suffers the loss would have to demonstrate a relationship between the vendor, the other party, and also that they had suffered a loss. Here, it would be the other way round. The vendor would have to prove that there was no loss or that they were not the cause of the loss. The other thing, which was an interesting draft provision, was the AI vendor would or the person using the tool, so not the end user, but the company providing the service, would also have had to disclose a lot more information on their algorithm and how they were using it. And companies didn't like this. It was a competitive threat. All of a sudden, you've got to tell all your competitors what you are doing. This was dropped. When the EU put out their workbook a couple of months ago, it was relegated to about 3 lines in an appendix. It wasn't even in the main body of the document. that they had decided not to proceed with this because they couldn't come to an agreement. And one of the reasons they couldn't come to an agreement was the world of PR. You can go onto the website and see all the people who were doing lobbying. And you can see the companies that they were representing. Microsoft, Motion Picture Organization, TikTok, doctors, LinkedIn, Meta, Google, all the usual suspects. But also on the other side, the Irish Council for Civil Liberties, the European Consumer Voice, Algorithm Watch. So this is one of the reasons why it took so long, and the fight isn't over yet. We went through lots of iterations. One very interesting thing was when the first version came out in April 2021, to be within the definition of AI, you had to use technology listed in an annex or an appendix. November 2023 comes along. What happens? ChatGPT launches. ChatGPT technology was not in the list of the annex or appendix. ChatGPT was not within scope of the definition. Panic! Quickly change the definition. How can we do this? How can we get agreement? Let's take the easy way out. We'll adopt the OECD definition, which is what they did. 2 weeks later, what did the OECD do? We are reviewing our definition of AI. Catch up with that in a second. So there's the definition we have today. It's in Article 3. We now have some guidance which came out in February. It's non-binding. So some people are saying it's non-binding, so what's the point? But of course, it could be persuasive. If you find yourselves in a legal debate, you might be able to rely on it as an indication of best practice. And all it does is it breaks apart the definition in Article 3.1, over 12 pages. But if you read it, what they basically conclude is there isn't a real definition of AI. The technology is moving very fast. If we put a definition in today, we could have another ChatGPT moment. So we need to be flexible. But the key thing is that AI takes some inputs and infers an output. That's the key thing. So that's it. Various definitions of AI. We have one in the Act. We have guidance. But the end result is it depends. Right. Each man in his life takes on many parts. There's a value chain for AI. There are several roles defined in the Act. The provider. Now, interestingly, they don't say the developer, they say the provider. And that provider could also be perhaps one of your clients who takes someone else's product and then may enhance it or put their trademark on it. The provider has the highest level of liability and responsibility in the chain. But they may be someone outside of the EU. So they need someone to import the software, the application, the service into the EU. To do that, the EU authorities want, as the colloquial phrase is, a throat to choke. If you're going to offer a product or a service using AI within the EU to the citizens of the EU, you must have an authorized representative within the jurisdiction, within the EU. Someone they can get hold of, someone they can prosecute, someone who can't say I'm outside of your jurisdiction. And then there's a distributor, someone who actually deploys it. So this is the person who's actually using it. And one thing to be aware of, and we've had some recent cases on this, you start off with an LLM, large language model, but then you start training it, tweaking it. And it's a bit like having a car, or you know, for those of you with only fools and horses memories, Trigger's broom. I've had this broom 27 years. It's only had 14 handles and 17 different heads. I don't remember the exact figures. There comes a point when you have changed the original model and it is now a new model. And that means that you, even though all you're doing is tweaking it, have the same liabilities and responsibilities as the original developer. And then, of course, there's the operator. All of these different roles, and you can occupy more than one role, have different risks and liabilities. Right. Much ado about nothing? Well, there's a lot of risks potentially out there. Here are some of them. We've mentioned copyright. The reason there are cows there, the very first copyright case ever reported goes all the way back to the time of the saints and a saint in Ireland. And I've forgotten the name now. I should know it. But someone goes to stay at a monastery in Donegal, where they have one of the few copies of the Bible. And every night he creeps down and he copies out from the Bible to make his own copy. And he gets caught. And the abbot of the monastery says, "You must give me back a copy, give me back everything you have made." And the judgment that is finally made is to each cow, each calf belongs to their cow mother. So if you take a copy of something, it belongs to the originator of it. We've got the stuff with static knowledge you've probably heard of before. Misuse and fraud. Increasingly, AI is being used in nefarious ways. Hallucination, just mentioned that. Black box. One of the requirements of the regulations is you must be able, and it also comes a bit under GDPR for credit scoring, you must be able to explain why the computer, why the AI engine made the recommendation it made, particularly if it impacts you in terms of getting employment, of getting credit at a bank. And this is a challenge because with some of the new models, LLM models, there's like 1 billion nodes or transformers in there. And then we've got the whole data privacy, data quality issue. Information about you may be being loaded in. There is a case which has just started where someone deliberately put in false information about another individual, which has been adopted and perpetuated through LLM models. So data quality, data poisoning type thing. Then we've got the ownership. I mentioned the intellectual property rights thing, and the liability. Liability is significant. Does anyone know what the fine is potentially for GDPR breaches? For GDPR, it's up to a capped amount, or for, can I hear someone who's going to suggest the answer? No?
I was going to say 2.5% of total revenue.
No. Up to, I think it's 20 million or 4% of global group turnover in the previous year. So not just your country, if you're a multinational global group, even outside of the EU. For the AI Act, depending on the type of infringement and the role, it can be up to 7%. So the regulations, data protection, various other ones, have all moved to become a percentage of turnover so that it relates to the size of the company. I can remember many years ago, a couple of decades ago, being in a large bank in London, talking to a client and explaining the liability that they may face. And the guy said, "It's not too bad, it's only a rounding error." Nowadays, they're not rounding errors. Right. The EU AI Act does have a hierarchy of risks. There are prohibited acts. You cannot use it for social scoring, mass surveillance, or manipulation of behaviour. There is an exception. There's always exceptions. If you're the government or the security services, this doesn't apply. As an indication, some of you may, there's a case in Norway at the moment to do with gambling, their lottery, with the way that the application worked. There was also a famous case a couple of years ago, which wasn't on the AI Act, but was on some specific US legislation on dark patterns. So a software games manufacturer called Epic Games, who make a game that your children may use called Fortnite, were deploying techniques in their game to encourage people to stay on, to make purchases, and to make it very difficult to cancel the contract, you know, when they signed up to be a game player. So they manipulated their behavior, and this is now totally forbidden. I'm not saying it won't happen, but it is forbidden. Mentioned Bridges, mentioned Epic Games. Most applications are going to come under the high risk side of things. And if you're a high risk application, you've got loads of requirements with which you must comply. You've got to obtain a conformity assessment to show that you're in conformance with the regulations. What does that mean? Well, you've got to have a risk management system. You've got to have a lot of documentation. The point I made earlier, the human in the loop, as it's sometimes called. You've still got to have a human involved. I had a conversation with a bank recently, and they said, oh, if we put in AI, we can get rid of all these people who are doing our portfolio management. And I was a managed portfolio. I said, you can't do that. You've got to have a human in the loop overseeing. How do you know that something hasn't gone wrong and all of a sudden you're going to cause a market crash? You've got to have cybersecurity. Well, ask Marks and Spencer's about cybersecurity. High-risk systems have to be recorded in a European database of high-risk systems. You've got to have data and data governance in place. That's for providers. Deployers also have similar obligations. One of the other obligations, which I have to say is going to be interesting to see what happens on LinkedIn. If you use AI generated content or output, if what you do is generated by AI, so think of the recent picture of Mr. Trump as the Pope, or other pictures, other content, it must be labeled, clearly labeled, that it was generated by AI. Now, I don't know the exact statistics, but I'm pretty sure that a lot of what I read on LinkedIn these days has been generated by AI. It reads the same. And of course, you know, there's this whole thing with the M dash. Some text in there that it's all about transparency. Yeah, we can go with that. These were notes to me rather than anything to you. There's a whole thing around the definition of what's high risk has changed to now focus on significant risk, and there's some use cases listed in Annex 3 which keep on being updated. So new definition of what's significant risk, and it's spreading out into other things like the Digital Services Act. You need to do an assessment. So this is not a responsible AI assessment. Here's something that I sometimes raise with people in the discussion on responsible AI. How many times do you think the phrase responsible AI appears in the 114 pages of the EU AI Act of recitals and articles? How many times? None. Zero. It's not in there at all. And not only that, in 2019, an expert group under the EU came out with proposals for responsible AI. They came out with a tool called ALTAI, A-L-T-A-I, which was a questionnaire, a survey to determine whether your application was responsible, protected the fundamental rights of citizens. Was it incorporated in the EU AI Act? No. Is it a mandatory tool for assessment? No. Because of this tension, lots of things have happened during that negotiating and lobbying. So here's another example. If you have a high risk system, you are required to do an environmental impact assessment and to minimize your impact on the environment. Laudable, laudable. How much difference is there going to be in the processing, the computing power between a high risk and some other system? Probably not a lot. In my submission, this was a negotiation that went on between the parties that said, okay, we will do an environmental assessment for high risk if you do this. Very interesting that it's only high risk systems that require an environmental assessment. Also requires a fundamental legal rights. That's not responsible AI, it's legal rights. And as any ethicist will tell you, the law and ethics are not the same. I mentioned those sort of things. Yeah, so what all of this is telling us is that competition between protecting you as a citizen and promoting competition and innovation. And what we're seeing with various regulations at the moment is people are very nervous of what's happening in the US. If they deregulate, companies will want to develop and innovate in the US because it's too constricted in the EU or in other jurisdictions in Asia or wherever. And there's also this concept that's been introduced called the regulatory sandbox. Right. There's also some limited risk applications that we can just quickly mention. Chatbots, for some reason, are regarded as limited risk. But if you go to the Information Commissioner's website, you will see the case of Ticketmaster. Ticketmaster used the chatbot. The way that chatbots, robo-advisors work is they look at what's on the screen you're looking at, what information you've provided. So if one of those happens to be the payments screen and you put in your card details and the software has been hacked so that anything put into the screen gets sent to the hacker, you very soon find that people are saying, money's been taken out of my account and the only thing in common is that I used Ticketmaster. You can read the details of that case. Fascinating case because Ticketmaster are approached by different card companies, Visa, and by a bank, I think it was Revolut, and they deny it. They say it's not us, nothing to see here. Perhaps they needed better PR. There's also a case in Spain, which was a data protection rather than AI, but they were using AI to translate voice calls into text, and then they were analysing the text. And they were fined €6 million. It's not chicken feed, it's not peanuts. And one of the big drivers for that was they hadn't informed the people what they were doing and they hadn't got their consent. And this is going to be a big thing going forward for you and your clients. If you're using AI, you need to tell the people they're using AI and you need to get their consent. I've put there a couple of frameworks which are commonly in use, which may be of interest to some people. If you're working with your client, how can we make sure we've got a framework in place? Hallucinations. When I started putting together these slides, I asked ChatGPT to give me a picture of William Shakespeare smelling a rose. Would a rose by any other name smell as sweet? This is what it gave me. And I'm pretty sure that doesn't look like William Shakespeare. Because it's being guided by the data from which it learned. Anyone want to throw in any examples of hallucinations they've encountered? Perhaps a discussion for another day. Some hallucinations are deliberately caused. We now have this concept of either training data poisoning or model data poisoning. And this is pretty hot off the press within the last month. It's dated March the 6th, but I don't think it was published on that date. A news company, journalists, investigators, have discovered companies in Russia deliberately producing content and putting it out on the web with Russian propaganda, with the deliberate intention that web crawlers who are looking for data to use to train the LLM will pick it up and it will become embedded in the LLM. The LLM will then assume that that is correct information. This training data poisoning. We also have a concept of model poisoning, which is more to do with people and the way that they create a prompt. So, very important for you to know, unless you change the configurations on ChatGPT and the other products, anything you enter will be used as training data. And if you are putting in information about your business, your client, which is sensitive, which is confidential, which you wanted to use to generate a summary for internal usage, it will go out and be used in the building of that LLM. You might remember recently Meta Group were quietly putting a change in their terms and conditions to say that they were going to use data that you entered into Facebook for training. And there was a public outcry. Most people never read the terms and conditions, but a few lawyers did. Public outcry. Meta had to roll that back. So that model poisoning, two things. One, prompts can be used with the deliberate intention of messing up the LLM. And two, what you're putting in is not necessarily protected or private. You may be giving away all of your corporate and commercial secrets. Finally, just to wrap up, and I know I'm going over time, but then we did start a bit late in my defense. Few things I wish I had known. It's not always correct. It's rarely useless. It's great at giving you a first draft, but then you have to work on it. You still need to think. It can't give good legal advice. We've got far too many examples of bad advice, but it can help you to sort of structure your thoughts and get better phraseology. But it's dependent on the prompt you use. The better input, the better output. GIGO, garbage in, garbage out. There are a few dates you need to be aware of. You should already, within your company, if you use AI, have implemented AI literacy training for all your employees using AI. I mentioned the codes of practice, the new definitions we had of prohibited practices, the new definition of AI. I have been working, myself and a colleague have been working with the Commission on their consultation paper with new guidance, which was due this month. I don't think it's going to come out this month. There's a lot of debate over what's in there. And then we have things going forward next year and the year after, so that we finally get to the position, unless it changes, where everything is regulated to a greater or lesser extent. And finally, a gift for you, a roadmap for you to use for compliance. I'm not saying this is definitive. I'm saying perhaps you might want to use it as a basis for how you adopt and try and manage the compliance of AI in your organization. Right, I apologize. This has been a complete whistle-stop tour. I mean, the actual EU AI Act is about 114 pages. I couldn't squeeze it in to 40 odd minutes. If there are any questions, I'm happy to take them now. If you've got any other questions, comments, then please speak to the people at Folgate and they will get in touch with me. Other than that, thank you very much for joining us today. I hope you've learned something. If not, then there was a money back guarantee. Whatever you paid to attend today, you can get back, even if you didn't pay a penny. Great to meet you. Thank you very much. Any questions?
Don't jump off just yet, Mike. I do have a couple of questions, and I'm sure I'm
Okay.
not alone. But look, firstly, on behalf of myself, Folgate, and everybody that's on, and anybody that will see the video, thank you so much for presenting this, and thank you for adding an element of humour to one of the sessions that I think most people thought was probably just the dull legal stuff, but actually is clearly very, very important. Just going back, there's a lot of talk here about the EU AI Act for good reason. So again, just expanding on a few bits that you spoke about in there. So there is no, for many of us who are in the UK, so there is no UK AI Act. Has the UK just effectively adopted the EU version in a similar way to how GDPR approached, or is there a different something different for the UK coming?
Right. So a couple of things. One is the EU AI Act has extraterritorial reach. So if you are a vendor, a provider of a product or service from the UK that is being used by EU citizens, you are in scope. You would have to have an authorized representative within the EU, and via them, you could be prosecuted for whatever breach of the act that you make. Within the UK itself, we don't currently have any direct AI regulation. What we do have is a patchwork of things: copyright law, intellectual property law, GDPR, and then there are also sector-specific regulations. The FCA have got all sorts of regulations about fair treatment of customers, and there are specific provisions around, say, for credit scoring. So it is quite a complex patchwork of regulations. And we are seeing with regulations like GDPR has this extraterritorial effect. We actually have two pieces of data protection legislation in this country. One is the 1998 Data Protection Act, British, English Data Protection Act. But we also have the UK GDPR, which was part of the bit of legislation we retained after Brexit. That fantastic decision someone made for us to leave the EU. I'm saying that very tongue-in-cheek, by the way. And half the country voted for it, half against. So who knows?
We won't debate that one right now.
Okay.
Okay, and it's probably actually not a surprise that much of the approach and the style of the regulation and how businesses are adopting this is actually very similar to GDPR in terms of the timelines, the throats to choke, as you correctly put it, the training and the regulation, and the penalty structure as well.
Yeah, the adoption is interesting. There's lots of reports coming out at the moment from McKinsey, from the Big Four, from banks about how they are adopting it. What we saw before the act was a lot of fear, uncertainty, and doubt. It was like remember the Y2K issue, the world will end. And lots of companies were worried about it. And it happened at exactly the same time as all of a sudden AI came to the fore of public consciousness with ChatGPT. And I'm guessing, but every boardroom in the country was saying, how can we use AI? There would be someone saying from the IT department or from business saying, how can we use AI? How can we use it to identify new customers, to reduce costs, to manage risk? And then there was the other side saying, oh, what about the threat that this poses to us, to our business? Clients won't need to come to us for advice. They can do it with AI. They won't need financial advice from banks. They can do it with AI. So, all of those debates were going on. And then it's sort of, as Gartner would have, we've gone from the peak of expectations and some people are starting to see the trough of despair. So we've gone from AI will do everything into some very limited categories. I'm actually doing some research at the moment, looking at what banks have put into their PR newsletters and also their annual report and accounts in the UK. Every single one of them mentions the use of AI to a greater or lesser extent. But if you look at how they're using it, it's almost all in the same few areas. Contact centers, customer personalization, AML, money laundering, detecting suspicious fraud, and then some other back office stuff like summarizing documents or other things like that. So not customer facing, not connected to the outside world. So we've gone to quite a small subset of where AI is showing its benefit. And I'm not sure who it was. Something says it was Warren Buffett, but it may not have been him, said, I see AI everywhere except in the financial results.
Interesting. So I've got two other questions, and unless anybody from the group wants to pop one in the chat or ask directly, of course. From the legal perspective, in terms of clients contracting with other parties, where are you seeing language starting to come into contractual relationships, and how is that starting to dictate contracts, become involved in contracts, and what are the watch outs?
Right, this is a hot topic. A law firm did some research about a year ago. They went to all of the popular products, you know, Claude, ChatGPT, etc. And they looked at the contracts that people sign up to. And the burden of proof on you was significant. Basically, they give no guarantees for the performance or the accuracy of their output. Caveat emptor, buyer beware. In terms of the business to business contracts, we are seeing, I am hearing, I am reading some very specific requirements from clients in terms of liability, in terms of usage, in terms of compliance. There isn't yet a standard set. There is in the UK an organisation called the Society for Computers and the Law. If you go to their website, they have put together a group of experts, and they really are some of the leading lawyers in the UK, who have put together, and it's freely available, they have put together some standard contractual clauses that they recommend should be considered and adopted. They're not clauses from the regulator. They are clauses from an expert group, but it's a good starting point. At this moment in time, it's all being individually negotiated, business to business. There is a thing in UK law and in EU law. In the EU, they have the Unfair Contracts Directive, and that's really intended to protect the small business in a big business to small business contract. We don't yet, this is all new, we don't yet have cases. We have lots of cases on unfair contracts, but none specifically in AI. So it is something you have to watch. Very few people read contracts, but the consequences can be very significant and severe. I recently had a discussion with someone who had started a business. The business went up to a value of about 30 million, but they had got some funding at the beginning. For that 30 million that he and his partner, that's what the value of the business was, they ended up only walking out with a few $100,000 because they didn't understand some of the contractual clauses. The agreement with the funding party was they would get 2 times the 10 million that they put in, and basically there was nothing left. So they did all the work and someone else took all the money. Just an example of needing to read the small print of a contract. I know it's boring. There was also a case a few years ago with Apple. When you were updating your Apple iOS it said, you know, do you agree to the terms and conditions? And some wag had put in there a term and condition that basically said you agreed to your body being donated to scientific research by alien beings. So make sure someone reads your contracts.
Well, the reason I ask is I did see in a contract recently, and it's actually come up more than once now, about restrictions on what information you can use in an LLM about that business. Now, obviously protecting copyright and etc. But it was interesting seeing some language starting to creep in.
Yeah, and there's a lot of language there. It's obviously intended to protect the party who put the language in there. Um, and this whole thing I mentioned about security, you cannot be too security aware. Ask Marks and Spencer's, ask various other companies who've been hacked. Make sure if you're using ChatGPT, your settings are such that you're not sharing your data with the outside world. And that actually has been a big drag in a lot. You know, I specialize in financial services. Lots of financial services have been very nervous about the security around this. So what we are seeing is more and more people just using an LLM within their company on their data, but completely isolated from the internet and the outside world.
Yeah. So appreciating that you are not specifically a lawyer or an expert in the space of comms, but you do understand our world as well. If you were a leader working in the comms sector in an agency, in-house, etc., thank you very much, Caroline. What would you be focusing on specifically, given that it's generally an industry that is content intensive? It will be used at all levels already within an agency or an in-house function. If you were a leader in those businesses, what would you be thinking about? What would be keeping you awake at night?
I think the fact checking part of it, the due diligence, I I can imagine in that sort of environment, you've got masses of material that you're going through. You might be looking at company reports, you might be looking at research, you might be looking at market research, you might be looking at product data sheets and other information. Using AI to summarize that will probably save you significant amounts of time, but you need to check the summarized version that comes out. There's a lawyer, Sir Geoffrey Voss, he's the Master of the Rolls, the most senior judge in the Court of Appeal in England and Wales. And in one of his speeches, he says that he used ChatGPT to summarize some documents, and they came out with a hallucination. So he sent a prompt back saying, "Is this correct?" And it said, "Yes, this is correct." And he said, "No, I don't think you're correct because XYZ." And it said, "No, I am correct." And he responded, "But you're an AI engine." And it said, "No, I am not." So you need to check carefully what the output is. That's, you know, so you have the benefit, it can summarize, but you need to make sure what's been summarized is accurate. Because if you go and summarize all that information and it's inaccurate and you put it out on behalf of your client, you are not going to look good, and you may be liable for, as has happened with this new case, some defamation because you're putting out statements about a product or a person which are not correct. Then you've also got the copyright, the intellectual property risks, and that works two ways. One, are you absorbing someone else's intellectual property rights and infringing them and doing it knowingly? And that's why one of the regulations, one of the obligations under the Act is that you must disclose what training data was used. And secondly, the output that you're producing, is there a human in the loop? Have you got any intellectual property rights over that output? Or can your competitor just take your research, change the title at the top, and put it out as their own without breaching any copyright laws?
And what are the disclosure regulations, or what are the discussions on that? If you were to produce some content, which ultimately you are then going to be providing to a client or another party for their use, what are the current disclosure regulations in terms of how much of that was produced by AI, so that they in turn know what their liability or their ownership rights are to that content.
Okay, so this is one of the things that's currently under debate in version 3 of the guidance that the EU Commission is supposed to publish this month. At the moment, the regulations are a bit short. It just basically says you must disclose if the output was generated by AI. So, you're going to see the same sort of thing that you currently see with a privacy disclosure or a copyright. It's going to be relatively short statement that it has been generated by AI. There was recently a case reported, not a case, but an issue reported. The BBC News was being harvested by Apple. I should have put a reference to this in there, but it just came back to my mind. Apple were putting BBC content they had summarized out on their news feed. And the BBC complained because they were putting out inaccurate and misleading information. It was hallucinating with data from the BBC. And in the end, Apple were forced to stop using the BBC News data.
Interesting. And just one of the other points, one of the very on the timeline that you showed us for the EU AI Act, right at the beginning, back in February, literacy training. Can you just talk us through a little bit more? What does that training look like? How detailed is that for teams?
So I can give you the very short answer. The regulation simply says that you must provide, there's a de minimis level on the number of employees and some other regulations, but you must provide AI literacy training to your employees who use AI or develop it. It doesn't specify what that training is. There is no accepted certification within the EU at this moment in time as to what that training or the content or the syllabus should be. I think it will tend to be a bit like GDPR and health and safety training. Ultimately, this is purely, like all the rest of this, purely personal view, that what will happen is if there is an issue or a dispute, the employee cannot say, I didn't know. Every 6 months, everyone in the firm has to undergo a recertification on data protection, data privacy. You cannot then, if you breach that as an individual, if I suddenly said, oh, right, I'm going to send a list, decided for whatever reason, perhaps a malicious reason, but that's a separate thing. But I suddenly sent out a list of all our clients that would, by name or account holders, that would be a breach of data protection. There would then be some litigation, and the company's part of a company's defense, this generically, would be we provided training. So that would be part of the defense. The other thing, of course, is we need to keep on upskilling the workforce. We face so many changes, whether it's AI, data protection, the cloud. There's so much new technology coming in that we need to keep on educating the workforce on. What's that Richard Branson quote? Someone says, why do we spend all this money on training our people and then they leave? And he says, what if we don't spend all that money on them and they stay?
Very true. Mike, there are no more questions in the chat. We've used a huge amount of your time, and people are having to drop now, I think, because we've gone beyond the hour. If there are no other questions from anybody left on the call, I just wanted to say once again, thank you so much for your time. This has been really valuable.
My pleasure. And anyone who has any questions, then please get in touch with Folgate and we'll get them answered. Thank you.
Thank you so much. Bye-bye.